We are on the record in the Lovelady matter, case D19-593-140D. Please confirm your appearance, starting with the plaintiff's side.
Good morning, Audrey Beeson, bar number 10511, on behalf of the plaintiff, Jessica Lovelady, who is present and appearing by video.
And Your Honor, Louis Schneider, 9683, on behalf of Michael Lovelady. He's present here in my office with me on video, Your Honor.
Okay, good morning. This is the time set. The court set this on an OST on the plaintiff's motion for an additional count regarding contempt. We have show cause proceedings that are currently scheduled for December 3rd at 9 a.m. So that's really the limited focus. I will say on the date that we had our last hearing on October 13th, the court, I believe that morning while we were in court, the court had received an initial report from Mr. Ponzo. I was just alerted that a follow-up report came in, and I've just had a chance to briefly glance through that. He noted in his updated report there's been a concerning level of regression for Abby. So certainly the issue, the focal point for me today is the motion and Mom's request that I add an additional count of contempt for the show cause hearing coming up. And I've had a chance to read the papers, so I'm ready to rule on the papers that have been submitted. Ms. Beeson, it's your motion. Anything you wanted to add apart from what's in the papers?
Judge, I would just ask for clarification moving forward, because if you've read our reply, there were additional days that she's meet. Is the court expecting a motion every single time with updated dates, or will an updated affidavit the day before be sufficient? Because now I'm concerned that my client is having to go through all these expenses because Dad is not following court orders. And I understand due process, and I understand Dad's right to due process, especially when contempt is at play. But my client's constitutional right to have access to and parent her child is being trampled all over, and I need to protect that right of hers without it incurring thousands and thousands of dollars in attorney's fees before we even get to trial. So I would look for some type of guidance from the court on that particular issue.
Okay, Mr. Schneider, anything you wanted to add beyond what's in the papers?
Yes, Your Honor. Your Honor, I've got some grave concerns about the contact that counsel's having with Nick Ponzo. The last hearing, I specifically said it's as if she read the report before the report was released. And sure enough, verbatim, she had seen the report, or at least was told was in the report. And then magically, on an OST, Nick Ponzo sends another report today. Now, it's been the policy of these courts that counsel's not to have ex parte communication with a counselor. I want to know every time and what type of ex parte communication counsel's having with Nick Ponzo. And before we answer, and additionally, Your Honor, I'd also like to ask the court to consider appointing a guardian ad litem or an attorney to represent Abby. My client is not encouraging this child to stay away from the mother. He's told her she needs to go to her mother. He's told her it's court ordered she needs to go with her mother. This is a 15-year-old child, Your Honor. I've advised him he cannot physically force her to go anywhere. So I want to hear from Abby through an attorney what's going on without putting Abby in the middle. So I'd ask the court to consider appointing any one of the seasoned family law attorneys that are willing to do this, or even at my client's expense, to represent Abby so that she has a voice in this, Your Honor. And holding my client in contempt, I mean, I'm not sure how we're going to have him held in contempt unless there's some proof that he's told her not to go. And it's just the opposite. He's telling her to go. So I'd like the court to address the ex parte communication that's apparently going on, and whether or not you'd consider appointing an attorney to represent the child.
All right, Ms. Beeson.
What would you like a response to, Judge?
Any ex parte communication with Mr. Ponzo?
First of all, he is not court appointed. He is now my expert because there's no stipulation in order that was signed by Mr. Schneider appointing him as a reunification therapist.
I knew it.
Therefore, Mr. Schneider, please. Therefore, the moment that Mr. Schneider refused to sign off on any type of stipulation and order, he became my client's expert. He is still my client's expert. There's been no inappropriate communications. Did I talk with Mr. Ponzo prior to his initial report? Yes, I wanted to know what his thoughts were, because if his thoughts were different than what my client was telling me, then I needed to take a different course of action regarding possible settlement negotiations and to advise my client. My words came from my training. Mr. Schneider may not be aware of this, but I was trained as a parenting, and Mr. Schneider is now laughing. That's really nice. I was trained as a parenting coordinator. I have an LLM and ADR with a focus in mediation. I had 2 years worth of classes. So a lot of my training and my perceptions are from that, my experience as an attorney and a family law specialist. Now, did I see a report by Mr. Ponzo before it was given to the court? Absolutely not. I saw it when everybody else saw it, when it came into my email. Same thing with today's report. I saw it when I received it. I asked if he would be able to supplement his report, and he did so. But the words are his, not mine. What is in my motion and my reply are my words. The fact is, Mr. Schneider doesn't like what Mr. Ponzo is saying because it's in line with what I'm saying, so of course it can't be counted. We used Mr. Ponzo based on Mr. Schneider's request. He wanted us to use Mr. Ponzo. So now to say, oh, well, there's inappropriate ex parte communication when he wouldn't sign a stipulation and order, making it a court-ordered outsource evaluator, that has no merit. And my concern is that we have a 14-year-old child telling everybody what they're going to do, and a father who says, well, I tell her she needs to go, but there's no consequences. He asks her if she wants to go. He's not taken any responsibility for the fact that she's not going. He doesn't understand the psychological damage that is going to occur to this child. And we have a parent that is not doing what they are supposed to do. She is a child. We've, again, never asked him to physically touch her, but he is a court marshal. He should know that if you can't not follow a court order and there'd be no consequence. If Abby says tomorrow, I'm not going to do school, he's not going to say, oh, okay, well, because you don't want to, I'm going to tell you you should, but I'm not going to do anything about it. Then he goes out and buys her a bike the day that she tells my client she's not going. As recently as yesterday in reunification therapy, she told my client, I'm not going and you can't make me. And that's because she knows she has her dad's support. Whether he's saying he's supporting it or not, his actions demonstrate that he supports a 14-year-old child telling a parent she's not going to listen. He has not told Abby not to swear at her mother. He has said inappropriate things in front of Abby. It was very telling to me that he said, you're the one that walked out on us in front of Abby. She is taking this on. She is aligned with him, and she is damaging her relationship with my client. My client can't get the last 30 days back. So what? Is she now going to miss out on Thanksgiving and Christmas because we're allowing a 14-year-old child to decide what she's going to do? Currently, Abby has 2 Ds and 6 Fs. Mr. Lovelady has told my client that Abby is the one in communication with the counselors and Abby is the one that has the academic plan, and he'll give it to my client when Abby gives it to him. He's not parenting her. There are so many concerning issues here, Judge. We need the court's intervention, and we need it now, not in a month.
Your Honor, most concerning is the fact that we have...
Ms. Beeson, what's your position in regards to a guardian ad litem for Abby?
I don't have a problem with the guardian ad litem because what their job is best interest. But we already have a reunification therapist, a therapeutic person who has met with Abby, who knows exactly what she wants, who's made it clear. We're telling you exactly what she said she wants. But at this point, I think it would be up to the trier of fact, meaning Your Honor, rather than having a guardian ad litem step in. Now, if Dad wants to pay for a guardian ad litem, not a child's attorney, because we all know how the child feels, but a guardian ad litem to actually assess best interest, to have access to Nick Ponzo, that's fine.
Mr. Schneider, who are you proposing for the guardian ad litem?
Michelle Hauser, Dawn Throne, any of them. Dawn's probably going to be on the bench, but Your Honor, the intent here was reunification therapy, not an expert witness. So if Ms. Beeson wants to have an expert witness, now I want an expert witness, Judge. This is not what it was intended to be. This was to be therapy for the child, not to spin it and turn it on its head. And what she's done is she's ruined this therapy. It's my expert witness? Well, good. Now I need an expert witness, Judge. And now we can subject the child to more counseling with somebody else. This is not what was supposed to happen, Judge. This was supposed to be an independent child therapist, and now he's an expert witness for that side. And I've had zero communication with Ponzo, zero, because that's the way it's supposed to be conducted.
Well, here's where I'm at. The issue before me today is actually relatively simple. It's whether or not the court issues an additional order to show cause and includes that as part of the show cause proceedings on December 3rd. And I am inclined to grant the request and add this as an additional show cause. I'm not, and I get the fact that there have been ongoing problems and issues with additional time being missed. That's something that certainly the court can address. I don't intend or expect a motion to be filed. I'm not issuing additional orders to show cause, but certainly that weighs as part of the balance of what I'm looking at when we come back on December 3rd. I also get the fact that December 3rd isn't necessarily the end of all this. There are a myriad of other issues that still have not been resolved. The parties are still married, have not been divorced. So keeping that focus, I do want to give some direction moving forward because this is a significant concern. I would designate Ms. Hauser to be, I don't have a problem appointing her as the guardian ad litem for Abby. That's going to be at Dad's cost. And so she can be contacted for that purpose. Let me just say a couple things that I want both parties to understand. Abby is 14 years of age. It's my understanding she'll be 15 in April. She is nearer in age to preteen years than she is to emancipation, to be very clear. She's a 14-year-old. She is a child, and she's in charge of this show. And that's what I'm seeing. There is nothing, and I get the fact that we can dispute what's happened with respect to Mr. Ponzo's involvement, but at the end of the day, there is nothing in any report I've seen that provides any level of justification for Abby not spending time with her mother. There is absolutely no basis whatsoever for this court to make a finding that it would be inappropriate, unsafe, improper for Abby to spend any time with her mother. Now, I understand, as children get older, and especially as they advance in teenage years, sometimes the harder you push on mom's side, the more ingrained perhaps a child becomes. And the more difficult it is, perhaps, at times to repair that relationship. And we're not just talking about her relationship for the next 4 years while she's a minor, 3 or 4 years. It's really the relationship that goes beyond emancipation. And as I look at the landscape of where things are at and have to evaluate, we talk about the support that a parent extends to the relationship of a child with the other parent. And it's one thing to say, Abby, you should go spend time with your mom, wink, wink. And I'm not saying that's occurring. I want to be very clear about that. I don't know what's happening, but the problem is the custodial time is not happening. I don't think there's any dispute that it's not going on, and Abby has seized control. When I envision a parent who supports the relationship of a child with the other parent, I want you to understand this is what I envision. Because oftentimes we ask children to do things that they don't always want to do. Sometimes a child doesn't want to go to school. Does that result in physically forcing the child to go to school? Not necessarily. There's an expectation that a parent imposes on a child to attend school. Sometimes that might mean some form of discipline. Sometimes there's a punishment involved. That's not the highest level of parenting, though. For me, the highest level of parenting is when a child performs in whatever it is, whether it's attending school, excelling in school, or spending time with another parent, it's done because that child has a certain level of respect for the parent that is requiring that to take place, a certain level of respect and a desire not to disappoint that parent, that child would never cross that line, that child would have such a level of respect for her father and understand that her father expected her to spend time with her mother, that this would not even be an issue, that it's not an issue of discipline or punishment, that it's a parental relationship, that I respect my father so much that I'm going to go spend that custodial time with my mom. I respect my parents so much that I'm going to perform to the best of my ability in school. I'm going to step up. That's the level of parenting that I'm searching for with this child, because these are parental decisions and choices. It's not a matter of, and if a child, I got to say, if a child has written something that contains vulgarities and disparaging comments about the other parent, at the outset, I would expect an immediate discussion. You do not talk about your mother in that fashion, period. That is unacceptable behavior. You don't, because there is nothing in these documents, whether the report was however the report was generated, there is nothing in my record that would support this court saying that any mom should have any less time than she's entitled to. There's nothing there. And so when a child starts speaking negatively about the other parent, I'm waiting to see that dialogue from the parent that she's aligned with saying, hey, that is unacceptable behavior. You do not talk about your mom in that fashion. You don't use that language. That's unacceptable. And that child would have a sufficiently respectful relationship with that parent that she would never again engage in that behavior. That's the parenting I'm looking for, to support the relationship of the child with the other parent. And I'm not seeing it. We can talk all day about dad saying, I tell her to go. I tell her she needs to go. You need to go. She doesn't respect that. I'm not seeing that level of respect, that she respects her father so much that she would not disappoint him by not doing what he expects her to do, and he expects her to spend her time with her mom. It's not happening. So whatever's being said, whatever's being done, she's getting away with it. Because, hey, I can't force her. I can't force her to go to school. I can't force her to do anything. She's 14 years old. She's a child. If we want to turn over the keys to the children, we can do that. But right now, my function and role is I issue orders and I enforce orders. And that is through my power of contempt. So we have a contempt hearing coming up. I've made it very clear. I'm not holding Abby in contempt. It's up to Dad to make sure that she understands that she has sufficient respect for her father, that she would not disappoint him by failing to spend time with her mother. That's all I'm looking for. It's not a lot, I don't believe. Now, there are tools out there. I don't have any problem getting Ms. Hauser involved as a guardian ad litem, but something's got to change. And so we have our show cause hearing set up. Ms. Beeson, you're to submit your order to show cause for that was premised on the motion, and I will see you back here on December 3rd. That concludes our hearing. Thank you for your appearances.
Your Honor, I'd like to talk about the communication with Nick Ponzo. I thought he was supposed to be an independent witness, not an expert witness for their side. So I want a copy of all the communication that transpired between Ponzo and Ms. Beeson.
I don't have a problem ordering any communication needs to be exchanged. I'm a big proponent of complete transparency, so if there's been any communication, if we need, listen, I don't feel like I need any additional expert. I do view Mr. Ponzo's role as being a reunification expert, that he was trying, his goal is to reunify, and it appears it's going backwards. He references the fact that it's regressed. So to the extent, I don't have any basis to find it's been influenced nefariously in any way by anything that's happened, or that, but at the same time, I don't have any problem ordering that any communications to be exchanged.
Thank you, Your Honor.
I think Ms. Hauser may be a benefit to Abby, looking at what is in Abby's best interest. But again, she's 14 years old. Come on, Mom and Dad, she's 14. Establish that relationship where she respects you so much. And I know what it's like. I know what it's like as a child to do things that I didn't want to do, but I respected that parent so much that I would not disappoint that parent and not do what they asked me to do. So let's step up to the plate and perform. Okay?
Thank you,
Thank
Your
you
Honor.
for your appearances. That concludes our hearing.
Thank you, Jim.